Welcome to the PCI Practical Matters podcast. This is 10 Myths of Government Contracting, myth number 7. That's still Tim Sullivan, our host. Take it away, Tim.
Thank you, Fritz. Yep, we're on myth number 7, which is our documents, including our proprietary information and intellectual property, are safe with the government. Boy, there are a myriad of ways that doing business with the U.S. government differs from the commercial sector, and protection of a company's sensitive information is one of them. The most important thing for you to understand is that literally everything you submit to the federal government is subject to a statute, a law called the Freedom of Information Act, FOIA, F-O-I-A. This statute was enacted in 1967, based in part on the philosophy, to paraphrase Supreme Court Justice Brandeis, that sunlight is the best disinfectant. In other words, the more open and transparent our government is, the less likely it would be that improper conduct will occur. This doesn't happen in the commercial sector. If someone wrote to General Motors asking for a copy of your recent steel quote, there's no law or regulation requiring GM to respond. Now, in the government setting, though, millions of people and entities submit information to the U.S. government every day, and much of it is sensitive. Think about income tax returns or a major contract proposal. If that information were released to a third party, serious damage could result. For example, imagine what would happen if the Social Security Administration released your Social Security number to an unscrupulous person. For that very reason, the FOIA has protections built into it that serve to prevent the release of certain types of information. Now, think for just a second about what a company puts into a contract proposal that it submits to the government. It might include a unique technical approach, your Coca-Cola formula, if you will, or your entire cost structure, or a list of the key personnel you intend to put on this project. All of those things constitute sensitive and proprietary business information, and the release of any of that information would likely inflict serious competitive harm on that company because, for example, your competitors would know how to undercut you or outcompete you or go to hire to beat your team or hire your team. Under the Freedom of Information Act and the decisions that the courts have issued interpreting and applying it, such information would probably not be releasable if the company could persuade the agency or a court that releasing it would cause serious economic injury or competitive harm to your company. Now, what I have just described sounds like a fairly easy process, but like almost anything connected with government contracts, the process presents some challenges. Experienced contractors are well aware that their competitors are constantly seeking their information through FOIA and other means. That is why they take steps, very basic steps, in order to protect the sensitive information they submit to the federal government. First, it's important to educate your employees about the rules for protecting information that is submitted to the government. For instance, your employees must have to be taught to mark, that is, put a label on or a mark on all proposal information and anything else that is submitted to the government. It's got to be marked appropriately. Well, what does that mean? It means that in order to mark something appropriately under federal regulations, you follow the directive at FAR 52.215-1E, and that is called Restrictions on Disclosure and Use of Data. You must use the marking that is prescribed in that provision. Any marking that differs from the legend prescribed in that regulation will increase your risk and your exposure. So this very basic question, did they mark it, will be the starting point for any analysis that either an agency or a court will conduct if someone files a FOIA request seeking your information. And your failure to have marked your data appropriately could prove fatal to your position. I mean, after all, it's a little inconsistent for someone to not mark anything and then come screaming to the agency of the court saying, oh my God, you can't release this information. It's entirely valuable. You didn't act like that by failing to mark it. Next, if a U.S. government agency ever asks you to comment on a FOIA request that is aimed at your data, so they don't tell you who asks for it, but they'll tell you that someone has asked for a copy of your proposal to the Navy under the Freedom of Information Act. And they're required to come to you and say, hey, someone's asked for it. Do you have any objections to our releasing it? You better treat that request seriously and promptly. Don't put it in on the credenza behind you. You deal with it right now because the deadlines are short here. And in responding to the agency, you must make a compelling case why this information should not be released. You use all the supporting facts and make the case that the release of the information will cause your company serious competitive harm or economic injury. Your response should be a clear statement of your position, and it should cite to case law, that is, decisions issued by the federal courts, supporting your position. Also, as part of this response, I strongly recommend having the letter signed by a very senior company officer underscoring the importance of the matter. If a letter is going to be submitted by your outside counsel, your lawyers, it should be accompanied by a sworn affidavit or declaration by a senior company officer describing the potential harm that would be suffered if this information were released. Why do you have to do this? Because you are building what lawyers and judges call a record. If the agency should disagree with you in any material way and decide to release the information, they'll tell you this in writing. The only thing you can do at that point is to go to court. And any court challenge will be limited to reviewing the record that was before the agency. So all the court's going to do is look at the proposal that's at issue, the agency letter to you, your response or responses to the agency. That's the record. That's why the information you put in those responses is so critical. And that is why you don't save any ammunition for a later stage, because there might not be a later stage. You want your best record arguments on the record now. Now, don't expect these federal agencies to simply roll over because your letter has cited a bunch of recent legal decisions favorable to your position. The agencies have experienced personnel handling FOIA requests. A lot of them are lawyers themselves. They know the law, and it is rare that they will see an argument for the first time, that it ain't their first rodeo. They also know that the FOIA and the courts favor disclosure, that is, favor the release of this information. So your burden is heavy. Third, overmarking your information and your data could serve to undercut your position if a competitor files a FOIA request asking for it. In order to make a credible argument to an agency or a court, it will help if you can show that you were very careful in marking your data. This puts you in a much better position to challenge the agency's proposed release of the information that you did mark so carefully. The same approach holds true for marking your technical data. If you're a DoD contractor, over-marking it can really hurt your position. So you don't want to claim limited rights to every screw and bolt in there. Don't be ridiculous about that. It simply hurts your arguments later on. Now, in addition to protecting information submitted to the government, and with the major role that social media and electronic filings play in both our personal and our business lives today, we need to be very careful about what we put out there. For example, if two parties are in litigation in a federal court, their filings are available to the public online through a service called PACER. You might be surprised by what you can learn about a competitor by reading those PACER filings, and the big companies are all looking at them very carefully. The FOIA, the Freedom of Information Act, and its protections isn't going to protect you if sensitive information is available on PACER. So experienced contractors coordinate closely with their lawyers in determining what information can be included in their court filings, and they'll ask for a protective order if necessary to protect certain information. As for social media, a prudent business person will educate their employees about what types of things should not be posted. Technical papers, emails, blog comments about government officials, rants about a prime contractor's practices, and venting about a recent contract loss might make you feel good in the short run, but can have very negative long-term consequences. Once again, the FOIA is not there to protect you in this situation. You put that information in the public arena yourself.